Cast change, and now we're ready to go. Please proceed.
Thank you, Madam Chief Justice. Madam Chief Justice, and may it please the Court, my name is Anthony Magistro, and I'm here on behalf of 4 families, the Ashcrafts, Andrews, Michalskis, and Siders, who are landowners in Harrison County, West Virginia. Mr. and Mrs. Siders are here today in the courtroom. I want to start off talking a little bit about what this case is not about. It's not about whether the respondent should be allowed to do Marcellus shale drilling. We don't contend that our claims are the kinds of claims that would stop their drilling. Rather, the fundamental question in this case is whether the petitioners should disproportionately bear the costs without compensation and the burdens of the activities caused by this Marcellus shale drilling. In the record, there's testimony that these wells that are at issue in this case will transmit nearly 58 billion cubic feet of natural gas in a year's time. So we're talking about a large economic activity that benefits a lot of people in Harrison County, benefits defendants, benefits the people who own mineral interests. But the burden of that drilling and the burden of living there while these wells were drilled and while these operations happen is disproportionately borne by my clients.
Hey, let me make sure I understand something correctly right off the bat. None of the drilling activities, none of the well sites, none of the pipelines, none of the roads are on your client's property. Is that correct?
That's correct.
So you're basically talking about activity that's occurring on other people's property or public roads affecting your clients.
Classic nuisance, where that's what nuisances are. They are activities somebody else is doing on their property that interfere with your use and enjoyment of your property. It's the classic common law nuisance that goes back 400 or 500 years all the way to England.
But there's a distinction between a public nuisance and a private nuisance?
There is. I think in this case it's probably both, and that's not what the court ruled, though. That's not what the issue is. The court never got to the issue as to whether or not there was a nuisance here, a public nuisance or a private nuisance or any of those sorts there. Instead, the court found that no nuisance claim was allowed to be raised because of severance deeds that were entered into 75 to 100 years ago.
So in other words, your clients have the activity is not occurring on your client's property, but your clients have leased the oil and gas under their property.
Yes, sir.
Now, the leases that you're making reference to that go back
I mean, stop. It's not that they've leased. 100 years ago, their predecessors in title severed those interests to someone else, and those people, through their separate chain of title, ultimately leased those.
And there were a separate series of leases, what, in the 80s, 84, give or take? Are your clients lessors in those leases?
No.
Okay.
The 4 remaining plaintiffs in this case, 4 remaining families, have no contracts with the defendants either through leases, they're not getting royalties, they have no pipeline easements, none of that. They are people who live next door to nuisances and are being harassed by the activities that happen.
Well, now you indicated, or the order indicates, and I believe you've indicated, that you waived or did not assert any property or personal injury damages claims here.
We're asserting common law nuisance claims.
Okay. So is your claim strictly for nuisance then?
Yes.
Okay. And what kind of evidence was there relating to whether the use of, you're not challenging the right of the driller to go in and drill.
Right.
You're not challenging fracking. You've already said that.
Right.
That's not an issue before us anyhow. But what was your evidence other than, I think there was some evidence of trucks running over the road certain times of the day that weren't good, but what specifically was your evidence? Okay,
we had 2 forms of evidence. One is that the plaintiffs testified, and this is all detailed with the record citations in our briefs, but I'll just briefly summarize it. First of all, we had a substantial amount of noise, traffic, and odors. So, and these trucks are going by 100 a day, 24 hours a day. They are parked in front of my clients' houses. Their engines running, the big 18-wheelers, the hisses, noises, fumes coming off. That's one of the primary causes of the nuisance. Day in, day night, for a year or more, those trucks go back and forth. There's testimony that clients can't sleep. There's testimony they can't sit on their front porch and talk. There's testimony that, in addition, we have odors from the fumes of these trucks that are burning diesel fuel while they're sitting there parked around my client's house and driving by. Second, we have dust. The activities create a substantial amount of dust. There's a lot of testimony regarding your cars are covered with dust, your porches are covered with dust. Makes your outside of your house unusable. Third, there's light pollution. There's testimony that people can't sleep. One of my clients testified that it was like living with Mountaineer Field next door with the light shining on you. The lights are so bright they go through their curtains, through their windows, disturb their sleep patterns, disturb those. And finally, we have vibrations, that as these trucks are going by, the drilling's going by, your house shakes. Things rattle, those sorts of things. Now, none of this is things that cause damages, and if it's something that happens in 5 minutes one day, that'd be one thing. This is constant problems that these people are having.
Well, I certainly am sympathetic. I wouldn't want to live there myself, but I'm looking at the court's order, and what concerns me is that that the court, Judge Moach specifically found, he cited some of the transcript from the trial where he asks you, is there anything they're doing that would not be considered an implied right? Now, you may view it as excessive, but are they doing anything that's not implied or necessary to take place in developing these? And you say, no, not as I'm sitting here today. So you're not suggesting here, does your argument boil down to they have a right to do everything they're doing, they just need to do less of it?
I think they have the right to drill and to do what's necessary to drill, and so that would be what a nuisance trial would be. One of the factors is, did they have to do these things? Do they have to point the lights at my client? Do they have to keep the trucks running every day? Do they have to do all of those sorts of things? And I think there's probably on this record a factual dispute on whether or not that is the case. But more importantly, when you get to this Marcellus Shale drilling, the question is, and the legal question that the court determined was that by doing that severance, that the plaintiffs have basically given up their right, or their predecessors in title have given up their right to bring a nuisance claim at all. Which means if you, then there are no checks on the defendant's conduct. And one of the things in terms of whether it's necessary or not to what they were doing, and that is one of the factors, but whether or not it's necessary, they tell you that they've been trying to do things better since these lawsuits happened. That in and of itself is evidence that they don't have it to do it. And and I think it's interesting that this case is part of 200 or some cases in front of the mass litigation panel, and what do most of those cases have in common? It's these defendants are defendants. There are a lot of companies drilling in the Marcellus Shale region, but we have hundreds of people complaining about the conduct of these very defendants that are defendants in this case.
Counsel?
That to me says that they don't have to do it.
Counsel,
yes,
you started your argument out today, and you've cited it certainly in your briefs, the disproportionate share. We have obviously adjacent property owners here that they are frustrated with the carrying on of the drilling activities as you've described. But how are they disproportionately impacted compared to other property owners in the area? Is there anything unique to these petitioners, plaintiffs, that is any different than any other closely adjacent property owner in terms of the nuisance that they are complaining of?
The big difference is proximity. They are all within a mile of the drilling facilities.
So to my point then, so other property owners that are in similar proximity or maybe along the road that the trucks travel, they have similar exposure or frustration or nuisance. I'm stuck on your suggestion that these unique petitioners are disproportionately to other property owners. It seems to me that what's being complained of, all property owners in close proximity are exposed to.
I think if you look at the record, and you'll see that these petitioners are the ones that are in that proximity, and there are not others similarly situated. So you have a bunch of trucks driving down Route 50 in the rest of in the flow of the rest of the traffic. Maybe somebody living next door in Clarksburg will see those trucks go by with all the rest of the traffic. But when you get down close to this very small area where the activities are concentrated, those are the people that are having their houses shake, that are having the lights shined on them, that are having the trucks parked in the street in front of their houses. That's not happening elsewhere. And if there are, I mean, and I guess if there is somebody that is similarly situated, I would argue they have a claim too. I think we have, with the groups of plaintiffs we have in this litigation, have drawn a pretty good line as to who the people who came forward and said this is making our living unbearable. We've gotten those people. The people who are outside of that range are not the ones bringing claims.
My follow-up. Obviously, the original leases from the early 1900s. The issue of there's no dispute over their right to be able to go in and drill. And what I heard you describe, and obviously from all the materials, the trucks, the lights, all of these, clearly the mass litigation panel said were contemplated aspects of the necessary requirements to be able to access and drill for oil and gas. What is it? I understand the techniques obviously have changed, and we know that in the Buffalo case and others, what is it that's truly different today, not essentially contemplated in the ability to access the oil and gas and mineral rights?
Well, I think first of all, it's important to remember that under Buffalo Mining that we are talking about implied rights. Right. And this court has made it clear that where there's an implied right, the test of what's reasonable and necessary is more exacting. And that in order to be successful, it must be demonstrated that not only is the right reasonably necessary for extraction, but the right cannot be exercised without any substantial burden to the surface owner. So necessary isn't enough for them to win. If it's causing a substantial burden, we don't imply the rights. And I think the best case talking about differences in technology and what's reasonably contemplated is this court's opinion in Kell. Kell was a case involving aerial spraying. And in that case, in 1939, there was an easement granted for power line right-of-way. And then the power company wanted to come in and do aerial spraying. And the court applied the Buffalo Mining test and said that aerial spraying was not within the specific contemplation of the parties to the 1939 indenture involved in this case. Now, Marcellus Shale Drilling.
We understand Buffalo, you can't come in and strip mine. That's substantially impacted the surface. The case you're citing, aerial spraying, substantially different. But again, we don't have the property owners in this particular case about their surface rights. That's not what this is. This is adjacent property.
Okay.
And the conduct of being able to drill for the oil and gas. I think clearly those two cases are distinguishable in the facts relative to the ability to drill in this case.
Well, and my response to that would be, Your Honor, in 1902 or 1920, no one the drilling was with wooden derricks, not the industrial sites that Marcellus Shale Drilling. So clearing vegetation by hand versus aerial spraying, the analogy is the same. Likewise, the analogy between regular old deep mining and longwall mining, the mining cases. These are substantially different technologies that are substantially more burdensome. And I think it's also important to talk about the property rights involved. And there are 6 well pads at issue here, and 4 landowners. Of those from those 6 well pads, 24 horizontal wells have been drilled. So you drill down, and then they drill out. That's what Marcellus shale drilling is. Now, 3 of those 6 well pads, with 9 of the horizontal wells, do not take gas from any of my client's property. So all of the burden to drill those 9 wells, my clients, they're not taking gas from my client's property. There are no rights that they've given for somebody to create that nuisance. And of the remaining, only 5 of the 24 horizontal wells touch my client's properties at all. So most of this drilling is being done, and this nuisance that's being created is being done to get gas that is not under my client's property. It's not a situation where, Judge Claudius, your house is next to one of these wells, and they're drilling from Chief Justice Walker's property under yours. What they're doing is they're drilling to get Justice Jenkins gas and creating a nuisance on your property. That is factually what's occurring here.
I guess, first of all, you're not suggesting that that all of these wells should be with wooden derricks on the pieces of property that the gas is being drilled, correct?
Right.
You recognize that technology has changed.
I do.
That the methods of drilling for gas and oil have changed.
Yes.
Correct?
Correct.
Are you suggesting, though, that in order to get the oil and gas, that the companies that have the leases should go onto the property of the individual property owners, build roads, set up oil drilling operations on everybody's property, and in effect annoy or be a nuisance to everybody that has leased their gas, as opposed to, in this case, where you have 4 well sites that are covering thousands of acres of gas?
I think the answer to that is no, that's not what I'm suggesting. What I'm suggesting is that if the court is going to hold that nuisance law, that what the court held below was that they have an implied right to create a nuisance. That's that they implied the right to create a nuisance. So what we're suggesting is, what the law is that if you don't have an implied right to create a nuisance on my property to get gas on someone else's property. And so what the remedy is nuisance law. And that is, a couple of things happen. One is you compensate people for the annoyance and inconvenience. Or number 2 is that you purchase the right, an express easement, to do that. And when you're talking about the amount of...
But how can you purchase an express easement when you're not directly affecting the property that you're purchasing an easement for? Well,
first of all, you are directly affecting the property, and yes, that happens all the time. That's what happens in some of these other defendants who are not being sued, because they go into the areas where the other property owners are, and they reach an agreement with them and say, we're going to drill and we're going to pay you because we're going to create a nuisance.
Under the court's order, a petitioner similarly situated would not be precluded, and I think you had the opportunity, and tell me if you think your opportunity was inadequate, to present evidence about whether the manner and the scope of the fracking operation was unduly burdensome in the context of their rights under the easement.
And I think we met the test on that, and to show that it was. We have experts that said that talked about how different this is than it was before, and some of it's just common sense.
What did you have with regard to expert?
Well, I mean, I think we had Dr. Ingrafiat was a professional engineer that testified about how this drilling is different than what was done before and what was reasonably contemplated on those parties in 1920 or in 1930, about how about the quantity of drilling, the quantity of fracking,
Well, but I mean, I'm asking you to focus on what they had to say about whether the methods they were using or the techniques or the manner in which they were doing it was overly burdensome on the property owner when put in the context of what I think you agreed was reasonably necessary to produce this.
Well, I think the answer to that Justice Workman, is that those sorts of activities are necessary to drill oil and gas. That is the state. I think the court took my question out of it. By themselves, you have to have trucks drive down the road. You have drilling, those sorts of things. What our argument is that this Marcellus drilling is so over and above what was reasonably contemplated, they don't have an implied easement to cause this nuisance. And then what that gets me a trial where the balance nuisance, that doesn't mean I win. What that means is we balance the rights and a jury gets to decide, and you look at the factors whether they're...
Let's talk about that for a minute. Does the jury get to decide what's reasonably necessary, or is that a question for the court?
The jury gets to decide. I think the jury, under this court's law, the jury gets to decide whether it is a substantial and unreasonable interference with the private use of enjoyment. There's a bunch of factors to look at, and one of the factors is the social value of the activity that's being challenged. That is a fact. That is part of the test. And so the jury can hear about all this great Marcellus shale drilling, those sorts of things. And the other thing, it just occurs to me that I didn't get to fully answer Judge Klodge's question about, isn't this better than having people drill on all these different properties? Part of the answer to that is that when you go onto someone's property and drill, and they're actually drilling, there's a different set of rules that apply. And you have the property owner, the surface owner has protections. The surface owner gets compensation under our statutes. And so again, back to, so in this case where whoever's property the well pads are under is getting paid.
But that also raises an interesting question because, aren't the activities of these companies regulated?
They are regulated from standpoint. There are certain regulations that apply to these companies, and there are lots of permit violations in the record.
Well, were they all related though to soil and groundwater, weren't they?
Right. And so, but
were there any violations relating to the remaining nuisance claims?
They're not rules regarding those things. Yes, their activities are regulated, but they're not regulations regarding light. There's not regulations regarding truck traffic and noise and dust and those sorts of things.
Well, there are a lot of interesting legal issues here, but in my mind, I think one of the real questions is whether, and this is going to require a very close examination of the record, whether you put on a sufficient evidence to survive summary judgment on this issue of whether the rights that they enjoyed to drill this gas, whether they were reasonable in the context of your rights. And there, I'm just wondering, you told me that the people testified about that.
There's testimony on that.
Okay. What was your ex? Did you have any other, just your clients?
Clients and the ex.
You didn't have anybody say they don't need to be running this many trucks a day to drill or anything like that? No experts that say that wasn't reasonably necessary?
What the testimony was regarding the burden. And so whether it's necessary is only one of the factors. Because this is an implied right, there's the additional question as to whether it unduly burdens us. So even if it's completely necessary under the Buffalo Mining test, because there's not an express right, it's only an implied right, if we show burden, undue burden, we meet the test. So before you take away their implied right to be protected from a nuisance, the question, and this is a question of law, is whether or not they're unduly burdened, and I would contend the record on that point is very robust.
I thought you just told Chief Justice Walker that you thought that was a jury issue.
There's two issues.
Okay.
One is under the Buffalo Mining test as to what is an implied right, and the third factor on an implied right, which were strictly construed because they're implied rights, is whether the conduct creates an undue burden. First is whether it was contemplated. Second is whether it's necessary. Third factor is undue burden, and they can't win that this is not an undue burden.
Didn't your expert give the opinion that the impacts experienced by your clients are commensurate with normal shale gas operations?
Which doesn't mean it's not an undue burden. Yes.
Counsel, and again, This issue of where should these be sorted out, and should this not be a legislative question? When I think historically we've had truck weight issues, we have regulations relating to idling, and I'm thinking of some of the descriptions that you've outlined about the trucks, the dust. I know that there are issues of requirements of tarping, again, idling, weight limits. Why should this really not be an issue for the legislature to address rather than a jury issue on any given nuisance claim to decide what is reasonable or not?
And I appreciate you asking that question because I was just looking for the opportunity to throw that in.
You just got it.
Okay, first, there are two statutes that are already in existence, the Oil and Gas Production Compensation Act and the Oil and Gas Horizontal Well Production Damage Compensation Act. And these are horizontal and vertical wells involved here. In that statute, the legislature said exploration for development of oil and gas reserves in the state must coexist with the use, agricultural or otherwise, of the surface of certain land, and each constitutes a right equal to the other. Both of those acts, and I've got the citations in the brief, expressly preserve common law remedies. Third point is, after we filed this case, as you might expect, having been around the legislature, industry came to the legislature and tried to get the protections that you've suggested that they have. Tried to get, there was legislation introduced to say that you didn't have a nuisance claim if you were operating under permanent activity and you were within the scope of your permit.
But similarly, plaintiffs, the petitioners here, and the property owners could also go to the legislature and push for a clear right to pursue what they're trying to do here, or put into statute protections so they can have the quiet enjoyment of their land that they hope to have.
That would be possible to do. However, what I would suggest is what happened to that bill. 18,000 letters were sent to the members of the House, which then declined to take it up. And under this court's precedent in State versus Butler, which was the case over whether sexual orientation could be a hate crime, what this court said is legislative inaction is evidence of legislative intent. In this case, they gave the legislature the opportunity to give them this win, and the legislature rejected it by not passing those bills. So to the extent we already have statutes that preserve common law remedies, we have a common law remedy that goes back 500 years in nuisance. And then they tried to take that away and failed miserably. So to the extent of what is the public policy, how this court should resolve that, we believe this court should resolve that by letting the common law test go, letting a jury weigh the common law factors on nuisance and decide that those balancing of the rights. Or we believe that recognition of this claim then was going to lead to what should happen, and that is negotiation between the landowners who are there and the people doing the drilling to come to a fair resolution, so the benefits and the burdens of this Marcellus Shale drilling are shared by everybody.
On that note, I will turn it over to the other side and give you an opportunity to reply.
Thank you.
In a little bit.
Good morning. May it please the court, I'm W. Henry Lawrence with Steptoe & Johnson. I represent the defendant Antero Resources Corporation in this matter. Also seated at council table is Christopher Ham, who represents the co-defendant Hall Drilling. I will take the preliminary portion of the argument and then have reserved time for Mr. Ham to present, if that's acceptable to the court.
That's fine.
We're here today on the appeal that plaintiffs have taken from the order granting summary judgment by the mass litigation panel. We asked this court to affirm the mass litigation panel's ruling determining that the property rights that Antero obtained were sufficient to allow the operations that the plaintiffs are complaining of in this case. The panel laid forth the basis for its opinion, addressed the property rights that appeared, and I think the language that the panel used is probably most succinctly states the basis for their decision. And I read from paragraphs 37 and 38 from the decision, from the order that was issued by the panel. And there were questions earlier that were raised and addressed to plaintiff's counsel as to the evidence that was presented. And the panel very carefully looked through hundreds of pages, or quite an extensive amount of discovery. There were a lot of experts that were offered up in this case. A number were withdrawn by the plaintiffs. The case started out with allegations. The original proceeding before the panel inquired as to what the claims were. Were there claims for property damage? Yes, there were claims that were asserted in the complaint for property damage, almost similar to a trespass type claim, contamination on the properties, damages, physical damages to the properties. There were also allegations in the complaints of personal injury that were made by the plaintiffs. That was at the initial hearing. At the motion for summary judgment stage, which was in early 2016, these cases, the activity that occurred was started approximately 10 years ago. These were some of the earlier wells that Antero drilled in Harrison County, and these suits were filed in late 2013. They were transferred and consolidated before the mass litigation panel. There was extensive discovery. There were a number of experts. We had an initial discussion with the mass litigation panel where the panel sought to educate themselves on just exactly what Marcellus drilling entailed. They asked for a factual presentation and background. It was Judge Moats, Judge Swope, and Judge Hummel participated in that. Then we went back some period later for a hearing on the motion for summary judgment. By that time, the plaintiffs had withdrawn their negligence claim. They had a nuisance claim. Judge Moats very carefully, and Judges Swope and Judge Hummel, asked the plaintiffs, and the panel quotes that in the order, Mr. Magistro, are you claiming any personal injury in this case?
We understand that the only thing that's left is the nuisance claim. And I guess the question that I have for you is, does not the panel's order basically give your clients carte blanche to do whatever they want to, whenever they want to, however they want to, no matter what effect it may have on these plaintiffs?
It does not, Your Honor.
Why not?
The panel looked at the evidence that was presented to them and said the plaintiffs have not offered expert testimony that indicates that these activities were unreasonable or unnecessary in developing these minerals.
Well, they had testimony of the people who live there. I mean, you can rely on testimony of a layperson can you not, under the law, if things are obvious enough that a layperson could, their testimony could have value.
Clearly, the panel listened to and accepted the testimony that the plaintiffs had with respect to the situations that they experienced, the noise, the truck travel, the lights. But the panel said, and this is what I referred to earlier, paragraph 37, this is after looking at the evidence. The evidence was not contested. There was no factual issue. The panel said defendants are entitled to make use of reasonable and necessary methods to develop the minerals underlying plaintiff's properties, only where those methods have been shown to be wholly incompatible with the surface estate due to total destruction. May those methods be found to be beyond the contemplation of the parties.
But wouldn't that language... I'm sorry, go ahead.
I'm sorry, you go ahead.
Wouldn't that language only apply to the surface owners whose property was actually being affected by your activities?
No, none of these plaintiffs had well pads on their properties. There were several plaintiffs in the initial case. We started out with 22 plaintiffs. We're down to 7 plaintiffs now. Several have withdrawn their claims and did not pursue an appeal. Several of those plaintiffs had entered into agreements to allow the use of their property.
Sure.
These 4 plaintiff families did not enter into any such agreements and had no activities on their properties.
Specifically on their property, okay. And I guess this is a distinction that I'm not sure I've picked up on yet, or I don't understand. If these plaintiffs had not entered into leases, or if their oil and gas had not been reserved in prior conveyances, would they not then have standing to bring a nuisance action?
I'm sorry, would they not have standing, or would they?
Either way, take it either way you want to. Would they have standing or not?
Well, I think the panel looked at the severance deeds, and the rights were created in those deeds. So to the extent that there were no such rights in existence, then that would be a different issue for the panel to look at. But in these cases, there were 2 severance deeds, a 1903 and a 1905 severance deeds, by which the fee owner severed the surface, conveyed the surface to plaintiff's predecessors entitled, reserved the oil and gas and the right to take all steps necessary to develop and operate for those minerals. So in this case, there were specific, plaintiffs have referenced only implied rights. There were both express rights and implied rights that were recognized by the panel. Now, your question, Judge Claudius, as to whether or not a scenario would present itself where there were no such property rights, that wasn't before the panel, but my assumption would be the panel would look at that and determine what property rights existed.
Are you saying that based upon the evidence that the panel had before it, at least these plaintiffs' cases were insufficient, that's why summary judgment was granted, but that's not to say other people similarly situated that could present other evidence would have a case?
I think,
or could. I guess I should say could have a case.
I think the law that was applied here looked at the severance rights.
But when I read things that say, if I'm looking at the paragraph, you're looking at paragraph 37, are entitled to make use of reasonable methods. I mean, reasonable just sounds like a jury question waiting to be answered.
But the jurisprudence of this court is clear that that is a determination made by the court. It's an interpretation of property rights that exist. And the court, I mean, it was twofold. The court said, we look at this is an issue for us to decide on summary judgment, but it is a legal issue, and there was no evidence presented as to the activities not being reasonable and necessary for the development of these minerals.
But I think what's being suggested is if there was more evidence under your view, it would be a jury issue.
I'm not sure I agree with that, Your Honor.
It's an evidentiary issue on who you believe and what you believe. That's a jury issue.
If there are factual issues, that determination of the legal rights goes to the court as a legal determination. So the panel could make that determination under West Virginia case law that those are property rights that would be construed and interpreted by the court.
Well, in paragraph 38 of the order following 37, the court found there's no evidence in the record indicating Antero's methods are materially different from the extraction methods contemplated at the time the minerals were severed or acquired, or are incompatible or destructive to the surface estate. Now, I think that suggests, and I don't know if I'm on the same plane as Judge Claudius or not, though, that in the correct case, this may or may not be the right case, there are jury issues involved here.
I understand your question, Your Honor. I understand the proposition that is being presented. There were no factual issues that were presented to the panel, so the panel did not address that.
What kind of evidence was presented as to, was there evidence on how many times a day trucks came, how much light had to shine on the people's property, the dust, the things they were complaining of? Was there evidence on both sides as to whether the techniques were reasonable, but whether the amount and type of activity was reasonable or not under the circumstances?
Yes, Your Honor. We did, Antero and Hall Drilling did not contest the facts that were put forth by the plaintiffs, nor did the experts that were presented by both sides. So there was not a dispute as to whether or not a truck went by one time today or 2 times today or 3 times. There were not disputes. The defendants accepted
Well, was there
the
evidence
facts.
about how many times trucks went by, how much traffic, how much dust, how much effect this had? I understand you're saying their experts did not help them in this regard, but was there evidence that was quantitative in any way about whether this was being done in a proper manner necessary for enjoyment of the rights of the mineral holders? Or
Yes.
was there evidence showing that it was excessive and unnecessary and unreasonable? Because I share the concern that Justice Claudius mentioned, that I don't think that, even though you have strong legal rights to these minerals, I don't think that it's carte blanche to do anything and everything you want under our law.
And clearly, the defendants have not argued that, Your Honor. There was extensive factual development through the panel set forth the procedure when the case was initially filed to require fact sheets in an agreed format that the parties agreed upon for each of the participants, each of the plaintiffs. Those were submitted. The panel reviewed those fact sheets and agreed to the format. Those were submitted. There was written discovery. There were depositions taken. So each one of these plaintiffs was presented both through their fact sheet, their individual impacts, as well as through deposition testimony that was developed for each one of the plaintiffs.
Counsel, on this issue of reasonable and necessary that obviously the mass litigation panel deemed was the conduct of the respondents here, had a legal determination be made that the conduct was not reasonable and necessary, do you concede that then a common law nuisance claim by these plaintiffs would be allowable and is a jury question?
That issue we didn't brief or address that issue before the panel. So I'm not prepared to respond specifically as to that.
You're not willing to accept that the property owners, adjacent property owners, would have a nuisance cause of action subject to determination by the jury, absent a finding by the court, in this case the MLP, of reasonable and necessary methods?
Well, I agree. The panel determined that based upon the property rights,
Correct.
that it did not reach the nuisance issue.
Yeah.
Now,
you're not willing to concede that had they not made the reasonable and necessary determination of the methods by which the oil and gas were being drilled, that there would not be common law nuisance rights by these plaintiffs?
well, part of the discussion that we had was, is this, if you exceed the scope of your property rights, that typically is a trespass as opposed to a nuisance. And I believe Judge Claudius asked the question, is this a public, is this a private? One of we spent a lot of time with the panel, the different types of nuisance theories, public versus private. I mean, the roadway, there are a number of components here that would arise to public nuisance as opposed to an individual private nuisance type theory. The other side of that issue was, is this a permanent nuisance? Is it a temporary nuisance? There were issues as to the statute of limitations, that whether or not statute of limitations was told, whether or not the statute of limitations barred these claims from existing. And at the time summary judgment was briefed, the negligence theory was also a portion of the argument that was made. But with respect to your question, Justice Jenkins, we did not get to that point of what if. Is there a nuisance theory? Presumably the panel noted that there were common law theories that had been asserted, but said we do not need to get to that because we are determining this on the property rights.
If you'd like to share your time, this might be a good time to turn it over to your co-counsel. I think we understand your arguments.
Good, thank you. We ask the court to affirm the learned opinion by the mass litigation panel. Thank you.
Chief Justice and Justices, may it please the Court. I am Christopher Ham, and I appear here today on behalf of Hall Drilling, LLC. Hall Drilling is a Ritchie County, West Virginia, located West Virginia Limited Liability Company, which provides general construction, labor, roustabout, and transportation services to the oil and gas industry, including firms such as Antero. It is important to note, with regard to this case, that Hall Drilling does not own nor operate any of the compressor stations, transmission lines, well pads, well infrastructure, pipelines, water treatment facilities, or other facilities and equipment of which petitioners complain in this case. Furthermore, Hall Drilling does not perform many of the activities complained of by petitioners and their experts. Particularly, Hall Drilling does not conduct horizontal drilling, hydraulic fracturing, flaring, the operation of water treatment facilities, flagging, traffic control, gas compression, or transmission. For the most part, Hall Drilling has provided construction services to Antero, and it has provided transportation by transporting water in water trucks. The orders of the Mass Litigation Panel, both granting summary judgment to the defendants in this case, as well as denying the motions to alter or amend judgment, should be affirmed in all respects as being correct. The gravamen of the panel's decision here was that Antero did not exceed its property rights in the efforts it made to enjoy its mineral estate. Hall Drilling was determined to have full benefit of those property rights as it was acting as a contractor to Antero. So Hall Drilling essentially was piggybacking on the property rights of Antero. There has been no evidence that anything Hall Drilling did in the Andrews case constituted a nuisance, either public or private, to any of the remaining plaintiffs. The expert's testimony in this case did not deal with Hall Drilling. It dealt solely with Antero's activities, and it dealt mostly with Antero's infrastructure and other related infrastructure in the area for the transportation and production of gas. It's important to note here that Hall Drilling has always asserted that it cannot be held liable for the acts or omissions of Antero, nor can it be held liable for the acts and omissions of any of Antero's other contractors over which Hall Drilling had no control. And I'm not aware that that's in any dispute here at all. When the experts of the plaintiffs with regard to the oil and gas industry were deposed, I specifically asked them, what was done here that exceeded what was reasonable and necessary for Antero to reach and enjoy its mineral estate? And the answer was uniformly that that was not their opinion. Their opinion was either that this sort of development shouldn't be happening at all, or that the issues had to do with the maintenance, the ongoing maintenance and operation of infrastructure. No expert on the side of the plaintiff has testified at all that one more truck was used, that one more truck trip took place, that anything occurred that went beyond what was reasonable and necessary to drill those wells and obtain the oil and gas. Plaintiffs will have you believe that as their surface estates get smaller, they get additional protection from the operations of the subsurface owners. In this particular case, there were 4 surface parcels that at the time of severance in the early 1900s came out of 2 much larger parcels. And at the time, there was 103 acres and some 200 acres of surface and oil and gas. The plaintiff's argument would have you believe that as the surface estate after severance was subdivided and subdivided and subdivided, that you continue looking to those boundaries and that you can't affect the surface of a 10-acre parcel that was subdivided out of 100 acres of surface. You can't burden that 10 acres except to get the oil and gas directly under it. That isn't and never has been the law in this jurisdiction. I would urge this court to affirm the orders below as being correct and right in all respects. And if you don't have any questions.
Okay, thank you.
Thank you.
A brief rebuttal.
Brief.
Well, first let me ask,
Sure.
why is Hall here?
I would say, if you want me to be brief, I would suggest that they raise those issues. We responded to them. The court hasn't ruled on them, and I don't think they're ripe for their names are on some of the permits. We would disagree about their conduct, but that would be a matter that if this court grants our petition and remands the case, that they would be entitled to have a ruling on their summary judgment motion raising those claims.
Something I meant to ask Mr. Lawrence, and I'm sure you know the answer to just as easily. Is this temporary activity? Think it'll be done in a couple of years?
Temporary, but not short, and they have permits that some of these pads, I believe, there's the ability to do more horizontal wells. They've got the vertical well. They can do other horizontal wells from these same pads, but that's so. Yes and no, I guess is the...
Yeah, I mean, most of the activity occurs during that period of time that they're drilling the vertical wells and then they're drilling the horizontal wells.
Yes.
Once those wells are drilled and the fracturing is done, then it's pretty much just a matter of
there is some
pumping the gas out.
There is some noise and other flares and things that happen just as with the normal operations, but I would agree with you that the real problem is during this period of time where the intense drilling activity has occurred.
Okay. How long has it been going on?
I mean, I think with respect to these, I don't think there is any current drilling activity with respect to these plaintiffs.
Okay. Have the
2009 is when it started.
Okay, so 9 years ago. So I mean, have the issues that brought us here, have they abated to any extent then?
To the extent they're not drilling, there aren't trucks going by their houses. Those sorts of things. That there is the noise from the compressors and those other operations that are ongoing.
But you agreed all those things were necessary. But I'm harking back to the same thing. What evidence did you have that while agreeing that driving the trucks, having light, doing all these activities were necessary? Even your experts said it. What specific evidence did you have that was unduly burdensome and that it was well in excess of what was necessary for them to enjoy their rights?
I think there are 2 points that I would make, Your Honor. One is necessity is one factor in a 3-part test. Contemplation of the parties is the first factor. I think that it is unquestioned that in 1905, this was not among the contemplation of the parties. Necessity is the second. The third factor, however, is substantial burden, absence of substantial burden. To imply rights to do something, to imply rights to create a nuisance, which is what the panel held, that they have the implied right to create a nuisance, they've got to meet those 3 factors. And whether or not it was necessary for Marcellus Shale drilling, I mean, I think common sense says you can point lights on your well, not on my house. There's
If you have to have trucks to go in and out.
But you don't have to have trucks.
You don't have to have trucks.
You don't have to have trucks sit there with their engines running, honking their horns, doing those.
But you had evidence of how many trucks, how many were necessary, and how many weren't.
I think there's evidence that the manner, how much greater burden this is than regular drilling. That's what the evidence was.
So
that it was not in the contemplation of the parties, and then the manner.
I'm focusing on the third factor.
Okay.
That's where I want to see if you
on the substantial burden.
Whether you did enough to survive summary judgment.
And I think that what I think the best thing to do is on pages 5 to 12 of our brief, we summarize the testimony with record cites to the depositions and the experts' depositions and the experts' reports. I think there's enough there to create a factual dispute on contemplation of the parties and on substantial burden.
Sure. What is your best case cite on this change of contemplation? I'm respectful of 1903, 4, and 5, and yes, nobody contemplated horizontal drilling or hydraulic fracking, no question about it. In the idea of the techniques that would be come on board later. But they certainly contemplated that the oil and gas would be extracted.
Sure.
So the lease and the contemplation of the oil and gas. So you're concerned about the techniques and the contemplation of the techniques, not the contemplation that the oil and gas would be taken
I think
out.
there's no question that the lease has contemplated the gas coming out.
Obviously with the mining industry, and I think my great-great-grandfather was Fireballs Jenkins, coal miner, and I think about the techniques he used as a fireboss compared to today's mining techniques and longwall mining and methods. How then do you reconcile a mineral right lease to coal, to mine coal, that in 1903 or 4, which is very different than mining techniques today? I don't see you citing any cases that show that in the coal mining, a change in what was contemplated in the method of mining, not the extraction in and of itself.
I think well, first of all, I mean, I think that's buffalo mining, and in the cases
but that's a surface. That's obviously surface of strip mining versus underground mining.
And there are also the cases involving longwall mining versus regular mining. What the cases, we've cited them in our brief, the cases say is that you contemplate some subsidence with regular mining, but longwall mining is different because it almost guarantees subsidence. And this court says that was not within the contemplation of the parties unless it's expressed. I think Kell is probably the best case because the panel's holding that you have to have that it has to be wholly incompatible. That's not the law. Because if you look at buffalo mining and Quintain itself, which cites Kell, aerial spraying is not wholly incompatible. Longwall mining is not wholly. So it's more like the longwall mining than the aerial spraying, and that is, and so. In essence, read that requirement out of the implied rights test, and I think I want to. And then the panel, you noted paragraph 38. The panel found no evidence that it was material different. That is completely false on this record. I mean, our experts went through quite a bit of explanation how much more burdensome this is than regular drilling that was contemplated. Let alone, we didn't even talk about regular horizontal or vertical drilling as opposed to what happened in 1903. So there's plenty of evidence of that. And I think I want to